Hi, everybody. We are going to finish off equal protection today. And we see the slide up here, which is basically, as I told you in the very beginning, our roadmap for tackling equal protection problems. And what we see on the left is that there are two prongs. There are basically two ways that we can get to strict scrutiny when it comes to equal protection, and two questions that we ask before we determine the level of scrutiny. The first is the what. Is there an unequal distribution of a right that is fundamental? If yes, again, we go to strict scrutiny because we're suspicious of what the government's doing. Why is the government unequally distributing a fundamental right? Then question number two, is there a classification that's suspect? Same thing, if the government is making a classification and it's on the basis of a suspect class, we're again suspicious of the government and they really need to prove it up to us. So we go to strict scrutiny. We also know that under the who prong, there's this middle category for quasi-suspect classifications. Mostly those are based on gender. And again, we use this intermediate scrutiny. It's a little bit of a mushy level, except we know that it still falls within heightened scrutiny, that it's not rational basis. And then of course, everything else, if there's an unequal distribution of a non-fundamental right, or if there's another classification, we use rational basis, we defer to the legislature, and what we know is, or the government actor, and what we know is that if we use a true rational basis, the government action is very likely to be upheld. Now, moving along, we can see here language from the two big cases that we're going to talk about today. I'm also going to talk about Cleburne, but what I want you to note from the language is that the court in 1967, 1973, the court's not using the magic words quite yet. It's not using the modern equal protection language that we've been used to seeing. So we need to look for the general ideas. Fundamental rights closely scrutinized. We know that means that the court thinks there's a fundamental right at issue and we're going to use strict scrutiny. And then look at Rodriguez, fundamental right, strict standard of judicial review. Again, the language has become a lot more consistent, where we always say fundamental right, strict scrutiny, but I want you to be able to recognize in the earlier cases, well, the language is a bit fuzzier, not always as consistent across the cases, and even within the cases, that these are the ideas that we're looking at here. Now, just a little bit of review. No suspect classification, but unequal distribution of rights, which is another way of saying, let me go back 2 slides. If either of these 2 columns lead us to strict scrutiny, that is the standard that we will use. Now, as I've said to you before, on an exam, in the artificial law school world of an exam, I'm probably going to want to see at least review if one of the prongs leads to rational basis and another prong leads to strict scrutiny, and it's kind of a close call. But in the real world and on a multiple choice, we know that if either of these prongs leads to strict scrutiny, that's the standard we use because the government has done something that we're suspicious of. Now, back to this right here. What we see here, Williamson versus Lee Optical, excuse me, there's an unequal distribution of the right to sell glasses. That is a non-fundamental right, and therefore we're going to use rational basis. But then if we think back to Skinner versus Oklahoma, an unequal distribution of a fundamental right, the right to procreate, and that's going to kick us into strict scrutiny. Now, neither of these classifications, as you can see on the title of the slide here, neither of these classifications are suspect. Let's think about Williamson. This is a classification on the basis of occupation. And let's think about Skinner. This is a classification based on what? The type of crime committed. Are you a chicken thief or are you an embezzler? Again, that's not a classification on the basis of race or national origin or even gender. one other thing I want to highlight for Williamson here. So the state is unequally distributing the right to sell eyeglasses. We should all now see that as a typical economic regulation in post-Lochner, in our post-Lochner era. Again, that should immediately ring to us as not a fundamental right. There is no fundamental right to contract that is recognized under the Constitution anymore. And again, compare that to the right to procreate. That sounds like the other fundamental rights that we've talked about, the right to determine what language your child is going to learn in school. And we're going to talk about this in a minute, but the fundamental rights, we don't have a good test to determine them. In a sense, what we're just saying is they're really, really important. And that doesn't always give us a ton of guidance. Now, this is where we are. And this is a little bit more review, and it's what we just talked about in terms of the columns. If there's a fundamental right at issue, we're going to use strict scrutiny, even if there's no suspect classification. If there's not a fundamental right at issue, but there's a suspect classification, we're going to use strict scrutiny. This square here is just another visual representation of what we've been talking about, which is there are different routes to get to strict scrutiny and different ways to get to rational basis. All right, let's continue by talking about our first big case today, Harper versus Virginia. Excuse me, this case obviously deals with a poll tax. We see on the screen here a poll tax receipt. Now, a poll tax is a tax per head known as capitation. On the screen, you can see that this is a receipt for a poll tax. We see it's received by Florida Dwight. And it's important to remember that originally poll taxes did not connect to the ability to vote, but that changed during the Jim Crow era. This Florida poll tax is linked to the ability to vote. We see that the election district is part of the receipt. And this is obviously a darker time in our nation's history. And so let's start to look at the parties here. We have a co-plaintiff, the attorney. Let's do a quick kind of summary of where we end up in this case. It's a 6-3 decision authored by Justice William Douglas. And the court says that the poll tax violates the 14th Amendment Equal Protection Clause. The court overrules a prior precedent, Breedlove versus Suttles, and concluded that the eligibility to vote has no rational connection to the wealth of an individual. I underline the word rational here for a moment, but we'll see what level of scrutiny the court actually applies. It's heightened scrutiny, right? The poll tax, the court says, could not meet the heightened standard of review that we apply to restrictions on voting. Again, we'll talk about this more in a minute. Why? Because the court says that this is a fundamental right under the 14th Amendment. It's important to note here, there's actually no textual basis for the Supreme Court reversing Breedlove, because the 24th Amendment that outlawed poll taxes, it only applied to federal elections. And obviously what we're talking about here is a state election. This is an example of a situation where changing membership of the court and changing attitudes in society really propel a change in the law. So Harper is decided not as a race discrimination case, but as a fundamental rights case. But I want to talk for a moment about why that's the case, why that's true. Facially, let's think about the statute. What's the classification here? The statute divides between those who pay and those who can't pay the poll taxes. But facially, this is not a classification on the basis of race. So let's think about our language here. Disparate treatment, that's not race-based. Disparate treatment on the face of it is who can pay the poll tax and who can't. But there's a disparate impact on the basis of race. So what would we need in order to treat this as a classification on the basis of race, we know that we need not just a disparate impact on the basis of race, but we also need to show that the government had a discriminatory purpose. So the court doesn't take that route. Again, the route we take is the what column that we talk about on that chart. It's the burden. And let's go to our Kickstarter. So the quick conversation we just had shows why the court doesn't view this as an A2 case. Instead, this is an A1 case. What burden or benefit is being distributed unequally? The right to vote for elections for state office. And now we have, of course, the hard question, is that a fundamental right? Now, once we decide something is a fundamental right, that actually becomes the easier question because we know that we use strict scrutiny. We basically know how to apply that. But the harder question is, what is a fundamental right? Now, fundamental rights, and we don't have a good test, as I've said here, it's just the really important ones. So important that the court should be skeptical when reviewing laws that distribute them unequally. I mean, what does this tell us? It just tells us basically a right is fundamental if it's really important. And with Harper, the reason that this is a good case in some ways to teach is that we see how different methods of interpretation can be used to persuade a court. So let's talk about how we determine in Harper, excuse me, that there is in fact a fundamental right at issue. So let's go through talking about text, precedent, structure, history, consequences, and values. Now, for the text, the argument really is much better for Virginia than it is for the voters. For the voters, the text argument, and it becomes successful, of course, but it's not really a great argument based on the text, is the 14th Amendment Equal Protection Clause limits all state activities, and this denies people equal protection under the law. As I said, Virginia actually has the better textual argument here. Under Article 1, Section 2, and under the 17th Amendment, it's the states that establish voting qualifications. So the states would have this power. The 24th Amendment, as we've said, says that in federal elections only, you cannot have poll taxes. So if we really do rely on the 14th Amendment Equal Protection Clause in a case dealing with a state poll tax, it kind of makes the 24th Amendment pointless or irrelevant. Now, let's move on to precedent here. What are the voters, the plaintiffs, arguing here? They're comparing to other cases dealing with fundamental rights, again, Meyer, Pierce, Skinner, and they're saying voting looks really important. Voting looks arguably as important. What about precedent for Virginia? Virginia is going to make the argument here that we have precedent. We have Breedlove versus Suttles, and that upholds a poll tax. What about structure? So when it comes to structure, the voters are going to say the importance of voting to protect rights and ensure meaningful citizenship is baked into the structure of the Constitution. And they're going to point to Caroline Products, footnote 4, and talk about representation as reinforcing other rights, as being this building block right. What about Virginia when it comes to structural arguments? Virginia is going to say states are put in charge of voting procedures. That's the structure of our Constitution. They're going to point to federalism concerns. Anytime the US Constitution overrides state law, somebody's going to point to federalism concerns, and they're going to point to separation of powers concerns, which, as we've talked about, can be raised anytime the court overrides a state law. Okay, so that's structure. Let's think about history for a minute. There's a long trend towards greater voting rights, and that is helpful for voters. Voters are going to, and again, by voters, we're talking about the challengers here. They're going to say there's this trend away from poll taxes towards greater enfranchisement. What about Virginia when it comes to history? Virginia is going to say that states have had poll taxes in the past without any doubts as to their constitutionality, and that property qualifications for voting were well known in the framers' time. All right, two more. Excuse me, consequences and values. The voters, the challenges here are going to say when it comes to consequences, there's going to be a loss of trust in the government, and that this poll tax is just going to perpetuate race and class divisions. What about consequences when it comes to Virginia's arguments? They're going to say there are dangers of deviating from constitutional text, even if it's well-meaning, that we have to stick to the text. And then finally, when it comes to values, what will the voters, the challengers, argue here? They're going to say there's a right to vote, that it's important to expand franchise, it's important to oppose race and class divisions, and they're going to talk about the unnecessary exclusion of people from voting and how that could lead to a situation where we actually have people who are elected to office who were elected by a minority of those living in a particular district. Values when it comes to Virginia. We've already talked about a lot of these. Textualism, it's not in the text. Federalism, we talked about that, and separation of powers. So that's the overview of these considerations that both sides will use to argue this is or this is not a fundamental right at issue here. Now, just want to emphasize a few things. I mentioned Carolene Products, footnote 4. Again, Carolene Products says we need a higher level of review in some cases where we see a restriction on the political processes, because if we do something like restrict voting, it's harder for people to fix bad laws or to vote bad office holders out of office. We talked about the voting rights amendments and how really in this case, Virginia has the better textual argument here. And we see in red, the poll tax prohibition, it applies only to federal elections. And this is a conscious drafting decision. This part, excuse me again, this part might actually surprise you, but the US Constitution doesn't specifically say that anybody has the right to vote. We see here on the screen, it says, if a state allows somebody to vote for state house, then they may also vote for US Congress. And what we also see here is that the right to vote is basically defined negatively in the sense that we find out that there's a right to vote because the amendments tell us when you can't limit it, meaning when you can't disenfranchise people. Now, there are plenty of situations where states, for instance, can disenfranchise people, and probably the best known example is states have different approaches to disenfranchising people with felony convictions. They range from no loss of voting rights at all to permanent disenfranchisement. And again, just to emphasize here, the 24th Amendment, it really gives Virginia the upper hand in terms of a textual argument. The Harper plaintiffs are relying, as we know, on the 14th Amendment Equal Protection Clause. But if the reason for the 24th Amendment, and we see that here in 1964, if the reason for the amendment was to overrule a case like Breedlove, it very consciously only partially overrules it. Again, I know I'm repeating myself, but by covering only federal elections, this case deals with a state election. All of this is to emphasize again that the Harper plaintiffs really do have a serious textual problem here. And the dissenters in this case, the people who would vote to uphold the poll tax, think that this is just Lochner all over again, meaning judges being activist judges. And so let's unpack that for a minute. Does this look like Lochner all over again? Well, what makes it look like the Lochner era rulings? One, judges are enforcing unenumerated rights. Two, as we've talked about, there's no real guidance for what counts as a fundamental right. It just tells judges, if you think it's really important, then you can say it's a fundamental right. Three, judges are arguably ignoring the overall preference for deference to political branches. Now, what makes this different from Lochner? Well, one, there's more structural justification in the Constitution for treating voting as unique and as more important than, for instance, the right to contract. And in terms of values, obviously, the right to vote is very different from the economic right to contract. And so in those two ways, I think we see there are real differences from the Lochner era and the way that judges made their decisions in the Lochner era. Now, what does this bring us to? It brings us to what we knew, which is the court says it's a fundamental right and there's a fundamental right to vote. And from there, it gets fairly easy, as we've discussed, because we know what standard we use. We use strict scrutiny. Now, let's talk about the two government interests that I think we should discuss here. First interest, raising revenue. A tax raises revenue. Is this compelling? It might be compelling in the abstract, but these are really small taxes. And in any event, we have a serious tailoring issue here. Again, we're right here. Think of less discriminatory alternatives. Just use regular tax collection if you want to raise revenue, not disenfranchisement, not poll taxes. And the level of fit is all off. It leaves really big tax liabilities basically unenforced, and then these little tax liabilities, like $1 for a poll tax, which is a lot of money for some people, but in comparison to bigger tax liabilities, isn't that big. It leaves those unenforced. So it's basically saying we're focusing on little tax liabilities, not the bigger ones. So is there a compelling interest? Yeah, maybe in the abstract. Is it narrowly tailored? No. There are less discriminatory alternatives, and the fit is all off for truly raising revenue. Now, what about number two, which is not argued by the state, but I think is worth discussing, limiting the vote to, quote, good citizens. Again, Virginia doesn't explicitly argue this, but a lot of states, for instance, in the 1780s, had wealth requirements. They're eliminated only by the 14th Amendment. Now, is this compelling? Only people who are, quote, good citizens, and good, again, means you can pay the poll tax. Is this compelling? No. In fact, it's capricious or irrelevant. So that's another way of saying it's not even legitimate. So certainly it's not going to be compelling. Is it narrowly tailored? Well, maybe if we think that this particular interest is compelling, this is a good way of achieving it. But we're out on prong one. It's arbitrary and capricious. And so we fail. And this slide shows us that we fail strict scrutiny. We're going to pick up with the Rodriguez case in a moment. All right, everybody, we are going to move on, still talking about the 14th Amendment Equal Protection Clause, and we're going to move on and talk about Rodriguez. So the facts, and then let's get into the law. Texas public elementary and middle and high schools rely on local property taxes for supplemental additional revenue. This is on top of the money that they already get from states, from a state-funded program. Rodriguez sues on behalf of students whose families reside in the poor districts. And he challenges this public education funding scheme. he says that it harms poor students because their schools lack a property tax base that the other districts have. Now, they lodge a 14th Amendment Equal Protection Clause claim, of course, and the court rejects it here. The court says Texas's public education finance system does not violate the 14th Amendment Equal Protection Clause because distributing funding unequally among its school districts is not a 14th Amendment Equal Protection Clause violation. And the court decides to use rational basis both by looking at the fundamental rights prong and the suspect classification prong. With respect to the fundamental rights prong, the court says, at the very least, there's no fundamental right to a certain type of public education funding. The court's a little mushy on this. Sometimes the language reads a little broader, like there's no fundamental right to education. The narrower view of this is there's no fundamental right to a certain type of public education funding program, or even there's no fundamental right to a certain level of funding in your public school. What about the suspect classification prong? The court says no suspect classification here. This is not based on race. There might be a disparate impact based on race, but the classification is not based on race. And so the court at least purports to use rational basis. So Rodriguez gives us an opportunity to look at one case and again see how we should think about both the fundamental rights prong and the suspect classification prong when we're thinking through these issues. As we're beginning, just look at the difference in these numbers and how much spending there is in Alamo Heights, for instance, per pupil versus how much spending there is in Edgewood, and look at the racial breakdown here. It is clear that there is an impact based on race, that there's a disparate impact here based on how Texas decides to fund its local schools. But again, that's not going to be enough for the court here to say that there's a suspect classification at issue. So let's get right into it. Is this a race case? And obviously, as we've been talking about, facially, there's no classification on the basis of race, meaning disparate treatment will not indicate that there's a suspect classification. We know under Washington versus Davis and Feeney, you have to show not just disparate impact, but also discriminatory purpose. And what would discriminatory purpose look like here? It would look like proving that Texas chose to fund districts via property taxes for the purpose of imposing a racially disparate impact. And that's going to be really hard to prove. It's not that they were aware that there would be a racially disparate impact. That's why they chose this funding program, this funding scheme. And challengers are just not able to show that here. Let's move on and focus a little bit more on the Kickstarter. So we've been talking about A2 here. What about A1? What benefit or burden is being distributed unequally here? It's public K through 12 education funding. Now, as we know, the court has decided this is not a fundamental right. And I want you to notice something that the majority focuses on here. The majority is not convinced that the lower per capita spending is necessarily the same as low quality schooling. So let's look at these numbers. The majority is not convinced that the kids in Alamo Heights are going to get a worse education. They're going to have lower spending per pupil, but that to the majority is not a direct one-to-one of if you have lower spending, then you have a worse education. Now, thinking through the fundamental rights prong, again, our question that we're focusing on here is public education funding, should it be considered a fundamental right? And as we saw in Harper versus Virginia, we have to have some reasons for the court to conclude that this is, quote, really important. As I said, we don't have a great test for this. Excuse me. A fundamental right is a right that is really important, which again, not a great criteria for us to make our determination. So what are some arguments, and I'll explain why I have this slide up. What are some arguments for saying that education should be a fundamental right, or that a certain type of education funding should be a fundamental right? Well, one, we have precedents in the area of education, Meyer and Pierce, Brown v. Board, that seem to treat at least certain aspects of education as a fundamental right. Two, we have the structure of our democracy that, at least if it's functioning, should require an intelligent and educated citizenry. That's why we have this slide here up on the screen. Three, consequences related to federalism, if we are to say that this is in fact a fundamental right. And D, values. Maybe as a society, we want to say that a certain funding, a certain baseline funding for public education is in fact a fundamental right. What about the other side? What about the con side? What are the arguments for saying we should not view this as a fundamental right? Number one, there's nothing in the text of the Constitution. So who are judges to create new rights? Number two, the structure of our Constitution, and in fact, the structure of democracy, lets these decisions be made by the legislature. Judges shouldn't be making these decisions. Three, related to that, consequences of judicial overreach. Judges shouldn't be going outside of their lanes. Four, history. There's no history in the framing era, the framers era, that would indicate that they thought public schools and public education should be viewed as a fundamental right. Now, we have this James Madison quote up here on the screen, and this is a famous quote talking about the idea that a popular government without popular information or the means of acquiring it is but a prologue to a farce or a tragedy, or perhaps both. And what that underscores is something that we're talking about in terms of values and consequences. The idea that education really is foundational to a functioning democracy. Now, that, of course, in this case, does not mean that we're going to say a certain type of funding for K through 12 education is a fundamental right, but it does give us some pause, maybe about what our framers might think and our founders might think. Now, that is a longer discussion of A1. Let's now go back, because we did kind of an overview and now we're talking about more details. Let's go back and talk about A2. Is wealth a suspect classification? So we have quotes here from Harper and then from our case, Rodriguez. In Rodriguez, the court is skeptical that the laws actually classify people on the basis of wealth, because what the majority is saying here is a wealthy person might live in a district with low per capita expenditures on schools and vice versa. And part 2A of the majority opinion questions whether there's any class of people that actually exists here. And we can link this to the idea of discrete, from discrete and insular minorities. If we can't tell who's in this alleged class, how likely is it that there's invidious discrimination against the class? So let's do a little thought experiment. Let's assume, for purposes of our discussion, that the answer to step A2 in the Kickstarter is that the law does classify on the basis of wealth, and it amounts to rich people getting better public schools than poor people. Again, we might believe that's true. Some of you might be dubious, but we're assuming for the sake of argument that the law does create a classification on the basis of wealth. The wealthy kids get a better education than the kids living in the poorer areas. And so strictly speaking, this would be a disparate impact on the basis of wealth. And let's assume a discriminatory purpose. Let's assume a discriminatory purpose to create that disparate impact. Should this lead to heightened scrutiny? We've seen these factors before. Again, excuse me, we look at status versus conduct. We look at a history of subordination, political powerlessness, visibility and isolation. That's where we get that language, discrete and insular minority, stereotypes against this group, and the likelihood of valid justifications. And then we also, of course, just for good measure, consider our usual factors here: text, precedent, structure, history, consequences, and values. Now, in thinking through these issues, I think one of the things we have to ask is poverty what you do or who you are? And for the court, it really is both what you do and what happens to you, in the sense that poverty, unlike your race or your gender, is not something that you are born with. And it's something that can change. People can be born wealthy, they can become poor, and they can be wealthy again. And for the court, when you look at these particular criteria, they may see that there is some lack of political power, that there are some stereotypes about poor people, for instance. But for the reasons we talked about, status versus conduct, that being poor is not viewed as, again, the same as race or gender. And it's not something that you can necessarily quickly see. You can't quickly see if somebody's wealthy or not wealthy, but you can see if what their gender is or what their race is. Excuse me. Now, again, bringing up this question of poverty, is it what you do or who you are? I think what we all know now is that it's a combination of internal and external factors. And I don't think this is a place for a lengthy discussion about income inequality and the structural reasons for that. But I would say I do think this is the place for a discussion of the fact that what the court says, no fundamental right, no suspect classification. So what are we going to do? We're going to apply rational basis. What seems to be the government's interest here in allowing this inequality? And it really is the idea of funding schools locally, having more local control over funding, and following existing jurisdictional boundaries. So we can see here that the funding scheme or the funding program really is based on these existing boundaries. Now we can say kind of who cares, but that is in part what the government is going for in this case. Is this legitimate? Yes. Is there a rational relationship here? Sure, the tailoring is close enough, especially considering what I think the court is really worried about here, which is the dangers of federal court involvement. And that brings us to what I think is really, excuse me, the bottom line, which is federal courts don't want to fix the problem identified in Rodriguez. Federal courts don't want to fix this inequity issue. That's a job, they think, for states, for localities, and not for them as federal judges to try and basically parachute in and fix these funding issues. So now let's talk about Cleburne. I don't want to talk about the California Constitution right now. I want to talk about Cleburne. And we talked about this last time, but in the 1970s, sex classifications move from rational basis to this intermediate level of scrutiny. And this naturally brings up the question of, well, what about other types of classifications? Should they also be basically promoted out of rational basis? Should they also be viewed as at least quasi-suspect classifications and, excuse me, subject to intermediate scrutiny? Now, for the next case, for Cleburne, the question is about disability in some ways, and what level of scrutiny should be given to laws that classify on the basis of disability. Now, as a practical matter, a lot of this gets resolved under two federal statutes known as the Americans with Disability Act, a very famous statute, and the Rehabilitation Act. And so as a practical matter, this really isn't a constitutional question, but Cleburne is a famous case, and it allows us to have a little moment of additional review and to think through more of the questions in the analytical framework that we've been discussing throughout our equal protection discussion here. So here we go. Let's look at what we're talking about, and let's give a little bit of a sense of the geography here. In 1980, Cleburne Living Center submitted a permit application to operate a home for the, quote, mentally retarded, and they needed and asked for a special use permit for, quote, a hospital for the feeble-minded. And again, here's a picture. We have to talk about terminology. We're using this language because it's the language used at the time. Our terminology, thankfully, continues to shift. And today's usage, we would say, I think, developmentally disabled or intellectually disabled. We would not use this language. And again, I've said this to you in a number of different situations. We use the language that's in the cases and in the applicable, in this case, zoning ordinances. So in this case, Cleburne's zoning ordinance and the city's rules, the city says that CLC is a hospital for the feeble-minded, again, quote, and then it denies the permit. The City Council of Cleburne voted to deny the special use permit by saying it's not proper under the municipal zoning ordinance. And the court says that this denial, that the City Council's action denying the special use permit, that is the thing that violates the 14th Amendment Equal Protection Clause rights of the Cleburne Living Center, which I just refer to as the CLC, and its potential residents. Because what the court says here is it's based on an irrational prejudice against, again, using this language, the mentally retarded. The court does not give the, quote, mentally retarded quasi-suspect class. They don't say you are entitled to the same level of scrutiny as laws that classify on the basis of gender. Instead, and this is, we know this from the case, but instead the court says that that denial of the special use permit, it violates the rational basis test. We know that in this case, not everybody agrees that the court is truly using rational basis, that this is a real Caroline Products type of rational basis. So as always, let's start with a Kickstarter. What is being distributed unequally? A1, special use permits allowing a, quote, hospital in a residential zone. That's not a fundamental right. A2, what's the classification here? Homes for, quote, feeble-minded versus homes for others, including people with other types of disabilities. Back to our usual question, what makes a classification, quote, suspect? Part 2 of the opinion is really a discussion about whether to apply some form of heightened scrutiny. We've been talking about this throughout our discussion, and the majority decides not to. According to the court, there's a real biological difference here, number one. Number two, the court does not want to provide some sort of heightened scrutiny here, saying there are many well-intentioned laws that we want to allow. So think of laws that say you should hire people with handicaps, that you get special subsidies for hiring people who are at the time, quote, mentally retarded, even certain types of affirmative action programs for people with disabilities, that if we use heightened scrutiny, then those programs might not be allowed. Number three, the court thinks that there's a ton of variety within the class here. And four, I think it's, again, this idea of the judges saying, not our role. We would rather that the legislature make these calls, that it really isn't for us, again, to kind of parachute in and make this decision. Now, Cleburne claims that, excuse me, Cleburne claims that it is applying rational basis. But in his opinion, Justice Marshall says, this is not true rational basis. You're not being as deferential as you would be in a typical rational basis application. And so let's talk about that as we think through the court's application here. And again, the government's burden here justifying the unequal distribution of special use permits on use of land for, quote, a hospital for feeble-minded. All right. First interest here. The neighbors don't want a group home for the mentally retarded. Not legitimate, period. This is simple animus from neighbors. It's reflected in the record. We see a quote from the court: mere negative attitudes or fear unsubstantiated by proper factors are not permissible basis for the classification. Almost any asserted interest in general, excuse me, is going to be seen as legitimate, but not actual animus. And let's think back to the Marino case. That was the food stamps case. Also the Palmori case, that was a child custody case, because here it's basically the city giving credence to private bias, and the court just simply won't have it. Excuse me. And so the level of tailoring doesn't matter. So again, for this first reason, the idea that the neighbors don't want a group home there, a group home for the, quote, mentally retarded, what the court says is this is just pure animus. And so the level of tailoring doesn't matter. What about the second reason here? The idea of, excuse me, protecting the mentally retarded from mean or bullying junior high kids. Again, this is not legitimate, right? One, it's just blaming the victim. Two, it's ratifying another kind of not in my backyard animus. And three, it's speculative. It's not even evidence-based. So once again, as we saw with the first government interest, the level of tailoring does not even matter. What about the three, the idea that we just want to protect the mentally retarded because the location would be on a floodplain, so there's concern about flooding? That's a legitimate interest. But notice that the court says the tailoring is off, which is not typical for us for rational basis. The court says it's under inclusive because there are nursing homes that are allowed on the floodplain. Excuse me. Next government interest here, concerns about density. That's also legitimate, but again, we have an issue with the tailoring, which again is not typical for rational basis. What we have here, the court says, is it's under inclusive, given that there are other types of hospitals and old age homes that are allowed without permit. So what the majority is really saying here is that the extreme under-inclusiveness here, it shows irrationality. It's an indicator of animus. And so again, we need to ask ourselves, is this a true rational basis application here? Again, Justice Marshall says, no, you're kind of using a rational basis plus. You're using some sort of heightened scrutiny, but you're not telling us that you're doing so. So let's talk about that more specifically. In what ways does this look like more than rational basis? Well, one, the court seems to be looking at the true motives of the legislature, of the city council here. That's not typical for rational basis. Two, they're looking for evidentiary support for a reasonable relationship, not mere conjecture, not a mere argument even. Three, they seem less tolerant of under-inclusiveness, as we talked about. They're less tolerant of bad tailoring. They seem to demand a better fit. And what Justice Marshall says here is basically, if we're using rational basis, but we're really not, we're using something stronger to strike down this action by the city council, then maybe rational basis is getting too strict. And what he's worried about is that the court's going to go back again to this Lochner era style of judges basically stepping outside their lanes and striking down the actions of our political branches. And is that worry justified here? And I think the answer is probably not, because here it does seem clear that we have some sort of animus, that the neighbors don't want this home here, that maybe the high school and junior high kids don't want this home here, and that what the court doesn't want is for the city council to be able to bless that private bias. And again, this should, for us, kind of echo Palmori a little bit. That was the child custody case. So, excuse me. Should we add a fourth level of scrutiny here? The question is, should there be a rational basis plus that looks a little more like what we just talked about in Cleburne? And some lower courts have actually used the phrase rational basis with bite or rational basis plus, as I just said. Those terms have shown up in some Supreme Court oral arguments, but not in Supreme Court opinions. So where does this leave us? Basically with what I just said, that when animus is present in the record, the court seems to get stricter, more vigorous in its application of rational basis, and particularly when it comes to tailoring. I don't actually think this is a problem. It's only a problem if you think every application of rational basis should look exactly the same. But I think there are good reasons to actually view rational basis as a sliding scale that depends on the situation. All right, that concludes our big section on the Equal Protection Clause. We're still going to come back to these ideas and we'll still do a bunch of review, but for now I am going to stop the recording.